of chapter 10. All right, so the second half is business entities. So we're going to look at business organizations, types of business organizations. There are more types than those three, but the three main ones we look at will be sole proprietorship, partnership, and corporation. And I'll go ahead and discuss with you the end of chapter 10 and chapter 11 today. Okay, so you are free. You don't need to come here on Wednesday. So we'll go into details. First part or first one, let's start with sole proprietorship. What is a sole proprietorship? So someone doing business on their own. The person is the business. I am the business. So if I am a gardener as a sole proprietor, I am the business. Okay. There's no need to register the sole proprietorship, unless you want to have a commercial name, business name. If you want to have a business commercial name, then you have to go through a name search, and then you should register that name. But if you want to use your own name, no registration required. You just do business. You do business on your own, raise invoices on your own. You are a sole proprietor. You are a sole proprietor. You as a person, you are the business. Can you sell your business? Can you sell your sole proprietorship? No, you can't. You, the person, are the business. How come can you sell yourself? You can't. Maybe you can sell assets. Maybe you can sell the client's list, but you cannot sell the business as sole proprietorship because you, an individual, a human being, you are the business. So you can't sell. Right? This is going to be different with corporation. Corporation is different. But as a sole proprietorship, you can sell. Can you have employees as a sole proprietor? Yes, you can. You are a business. So you can have as many employees as you need. And if you have employees, do you have to comply with employment legislation? Yes. Yes, you do. If you have a place of business, an office, or a store, do you have to comply with zoning bylaws, licensing laws, etc.? Yeah. Yes, you do. You are a business. All right, so that's what a sole proprietor is. Sole proprietorship is. It is you, yourself, an individual, a human being doing business on their own. Can you have partners as a sole proprietor? No, no, you can't. If you want to have partners, you have to set up a partnership. You can't have a partner as a sole proprietor. Okay. Now, one of the best advantages here. It's as simple as I have just explained. You are the business, you start doing business, no registration required. You just start doing business. What is the worst part here? What is the most disadvantage of a sole proprietorship? You have unlimited liability for the business debts. And the fact that you have unlimited liability means that your personal assets are at risk. So the savings account you have, $5–10 million, they are at risk. So creditors, they will come after you. And if your business cannot afford, your sole proprietorship cannot afford paying the debts, they can come over your personal assets. That's the main disadvantage. How can we mitigate risks? If we have a liability risk, how can we mitigate liability? That's correct, insurance. So, as a sole proprietor, you could buy liability insurance. Are you eliminating your risk as a sole proprietor with liability insurance? No, you are not. Exactly. You are not eliminating your risk. You are mitigating your risk, right? Because it may be the case that you caused so many losses that you have used all your aggregate claims to your insurance. So a liability insurance does not eliminate your risks, but they help mitigate the risks. They help spread the risks. Are we good? So that's sole proprietorship. Do business on your own. Now, if you want to have, well, one last thing, vicarious liability. Well, because you have employees, if you are a sole proprietor with employees, you are vicariously liable for the torts committed by your employees in the course of employment. This you already know, just repeating this. Okay, we already know employers, they are vicariously liable for their employees. So now, if you want to have a partner in business, you need to go through partnership. You may go through corporation, but I want to set corporation out. It's going to be in the next chapter. So if you want to go with another partner or some other partners, because you can have one or more, as many as you want, partners in the business. And why am I saying partner in the business? Because you would be seeking profit. If you have a partner and you want to seek profit, you want to pursue profit, then you should form a partnership. So a partnership is a group of 2 or more people, because one person is going to be a sole proprietor. Partners, they have the same individual characteristic sole proprietors have. In other words, the partners themselves as people, they are the business. So you and I, we are partners. We have a partnership. Our partnership is called JI. So I am a partner, but I am also JI, the partnership. You are a partner, but you are also JI, the partnership. In other words, everything you do on behalf of the partnership binds the partnership, binds me as well as your partner. So that's very important. A partnership is also personal. It's on the people, on the partners. Okay, that's very important. When I tell you this, I'm telling you that a partnership is not a separate legal entity. Separate legal entity is a concept we're going to go through in corporations, not here. We people, the partners, they are the partnership. Well, a partnership should be created by agreement. Should. But there are circumstances that a partnership is created inadvertently, without intention. So it may be the case that you are in a partnership, or you were, and you were not aware. Because it may be the case you have created a partnership inadvertently. How does this work? Well, the Partnership Act, by the way, the BC Partnership Act, because the Partnership Act is provincial, so I'm talking about the BC Act. If you go to another province, you should look at that province's Partnership Act. They are similar in nature, but not the same. So the BC Partnership Act says that there will be a presumption of partnership. A partnership will be presumed if you have joint contribution of capital, if you aim to share expenses, profits, or losses, and if you share management of the business. But most importantly, if you are seeking profit. If you are seeking profit and contributing capital, sharing expenses and losses and profits, you are in a partnership. inadvertently. Simple example here. Let's say last Friday, you and your friend had an idea. You went out to buy baking ingredients to make muffins to sell at Stanley Park yesterday. Did you have a joint contribution of capital? Probably yes. You shared the money you invested to buy ingredients to bake. Did you have an intention to share the profits? Yes, you did. You want to make profit and you wanted to share. And you work together in this journey. Did you have an agreement? No, you didn't. You didn't even know you were creating a partnership. But yes, you did. You created a partnership by inadvertence or inadvertently. In other words, what I'm saying is, whenever two or more people join resources, share profits, aiming at profits, they are in a partnership, regardless if they have an agreement or not. Why is this important? That's important because partners, they are unlimited liable. The same as sole proprietors. Partners are unlimited liable for the partnership's debts. So your personal assets as partners, they are at risk as well. What if someone ate your muffin, got sick, had to go to the hospital? You're going to lose wages, medical, doctor's costs, etc. Sorry, they may want to sue you. They will sue the partnership if the partnership cannot afford, and most likely it cannot because you invested, let's say, $500, $1,000 to make the muffins. Now they are suing you for $20,000, for $100,000. So they will come after your personal assets. What if your partner is poor at a personal level? They are poor. They have no money, no assets, and you have money. They will come after your money. So it's very important to be cautious about creating a partnership by inadvertence. And by the way, I'm talking about general partnerships because there are two other types of partnerships we will discuss by the end of the chapter. So this is creation by inadvertence. Something that the Partnership Act says that if you own property in common, this is not a partnership. So you and your friend, you and your partner, you and your family member, you have a house in Whistler. You share the use of it. You share expenses. It's not a partnership because you're not aiming at profits. But if you are aiming at profits, if you purchase the property, then to offer for resale or for rental, then it would be a partnership. Okay. All right. So a partnership, a general partnership, should be created by contract. And again, I'm saying should because then partners, they would discuss, they would customize their obligations, their rights, how the relationship will be. So it's best to create through a contract. And you already know this from contract law. It's better to have a written contract so that parties know what their obligations are clearly, right? And when you create a contract, you can think or you can agree on different terms as the Partnership Act. So one example is, well, let's talk about the agreement and then I'll talk about the conflict with the Partnership Act later. So the agreement should have the duties, the time that will be spent on money, how profits are to be shared. What if there's a partnership? Let me use the pen. What if a partnership, let's say there's partner A, partner B, let's say partner A has only 10% interest B has 90% interest. Is this possible through an agreement in a partnership? Yes, it is. But you have to have an agreement. Because if you don't have an agreement, the Partnership Act says that profits and losses are shared equally. So if you don't have an agreement like that, it's going to be 50-50. But if you want to have 10-90, then you need an agreement. And then in the agreement, you can also have any limitations on the powers, any authority. Well, see how important is this? This is. I told you that there's unlimited liability on the partners. So, because there's a limited liability, and because whatever my partner does will bind me as well, so it may be that in the agreement, I will not allow my partner, nor will my partner allow me to get a loan without my consent. I want to have some protection. But if we don't have an agreement, my partner can go to a bank and get a loan. And that loan will bind me, will bind the partnership. See? So again, it's very important to have a contract. You can go online and you can find template partnership agreements, but the more serious you are about your partnership, the better it is if you hire a lawyer, if you seek legal advice for a customized partnership agreement. And then you would also discuss about methods of resolving disputes. So what if you disagree? Both partners disagree on a given situation. How will they solve this? Will they solve this through negotiation? Will they solve this through courts? What is the procedure to resolve issues or disputes? Well, registration is required in BC. If you form a partnership in BC, you have to register your partnership. Registration is $80-90. So, and this is the total amount you spend. You spend half of it for a name search, and then the other half to actually register the partnership. On Learning Hub, I have shared with you forms to fill out and share and fill out the forms and how you register the partnership. If you don't register the partnership, you may be fined. So that partnership you created yesterday or on Friday by inadvertence to sell muffin at Stanley Park, that one you were not aware, you had not registered, so you could even be fined for that partnership. And if you have an unregistered partnership, you cannot sue. You cannot sue on behalf of the partnership. So if any client, if any supplier caused your partnership loss, you cannot go after the loss in court because you have an unregistered partnership. All right, so as I said before, if you have an agreement, then you can agree on terms that are different from the Partnership Act. Because the Partnership Act says that profits, as I said before, profits and losses will be shared equally. No salaries will be paid to the partners. Partners, they will make what? They will make profits, the profit if they make profits. So if you want to have something different from the Partnership Act, you should have that or those different terms in the agreement. Okay? In other words, the partnership agreement is the main law of the partnership. And when the partnership agreement is silent, then the Partnership Act fills the gaps. Okay? There's a good and important advantage for the partnership, which is major changes, they require unanimous agreements. So even if I am partner A with only 10% interest in the partnership, but if my partner wants to have a major change, what is a major change? Change place of business, change type of business from reset from selling of products to now services, or then my consent is required. Unanimous consent is required. Okay, so that's a good aspect for a partnership. So you are protected even if you have less interest than your partner. This, as we'll see, this does not apply in a corporation. In a corporation, if you are a minority shareholder, you are just ruled out. Okay, but in a partnership, you are protected.
I have a question.
Yes.
What happens if somebody sued a partnership, but the equity of the partnership is less than the amount the suit? And partner B, for example, for the partner B, don't have anything out of the partnership. Then what the partner is supposed to do? Because when they sue, they go after their own equity.
Yeah. So what is it here? Unlimited liability. Third party can collect from any partner.
Yeah.
So your question is, let's say, there's a partnership agreement here, partnership agreement. And then there's a bank that is suing for, let's say, $100,000. Okay. Excuse me. So the bank is suing for $100,000. What did they say here? Third party, a bank, they can collect from any partner, any. So yes, the partner with 90%, they have no other assets, but they have assets. So yes, the bank can collect everything from them.
What the person is supposed to do?
Okay, this is an agreement. This is the partnership agreement. Does this agreement bind third parties? Only the parties contracting, right? Based on privity of contract. Okay, so they paid everything. Now they can sue B. They will not sue B because they know B has no assets. So they lose money. So you must know who your partner is before starting a partnership. It's a very, very relevant and important question. So even if you have very little interest, you face unlimited liability from third parties. That's very important. Did I answer your question?
Yeah, in fact, you must have access to all of the trades you're doing during the partnership. If it's not a partnership that the same amount of money as you, but lost his money on gamble or anything, and you're in deep.
Yeah, in order to avoid this, you would go through corporation. You wouldn't form a partnership. Or you would form a different partnership. We'll see in a minute. Okay, that's very important. Very, very important. So there's fiduciary duty. Partners, they owe each other fiduciary duty. But this is not new because agents, they owe fiduciary duty to their principal. And I told you before that partners, they are agents of one another. In other words, what I'm saying is the law of agency applies to partnerships as well. So if there's fiduciary duty in agency law, there's also fiduciary duty here in a partnership. And the fact is that there's fiduciary duty means that if I am a partner, I cannot compete with my partnership. I cannot do business competing with my partnership. If I am a lawyer and I am part of a law partnership, law firm that is a partnership, I cannot have clients on my own. Clients have to go through the partnership. Unless I disclose to my partners and my partners consent that I have clients on my own. But if I don't disclose, if I don't get my partner's consent, I can't compete. So there's fiduciary duty there. And as I just said, laws of agency applies, partners are agents of one another, and there's vicarious liability on all partners. So yes, partner A is vicariously liable for the wrongful conduct of partner B, and vice versa. Partner B is vicariously liable on the wrongful conduct of partner A. So you see how risky it is to be in a partnership. You can still have insurance, but again, insurance will not eliminate the risk. Insurance will mitigate the risk. Right? It's risky. However, it may be the case that you are in a partnership in which the core business is not that risky. Let's say you are in business of reselling pens. Okay, maybe that a child swallowed a pen and well, bad things could happen everywhere. But in general, if you purchase and resell pens, let's say simple pen, it's not that risky, as opposed to working with chemicals or services in which people rely to make decisions, etc. Okay, so depending on the core business, it's not that risky. Depending. Okay. So we just discussed this, and this is important. This is going to be in your exam for sure. This unlimited liability, this fact that one partner may have to pay out all the debts of the partnership because of unlimited liability, and then a partnership will be dissolved when, if it's a partnership of two only, when one passes away, the partnership is ended. Because there can be a partnership with one only. What happens with their interest? So let's say partner B passed away. Well, it depends on the partnership agreement. The partnership agreement may say that when partner B passes away, or when any partners pass away, their interest will go to their heirs. And their heirs will be accepted into the partnership. Or not. It may be that partner, the remaining partner may appoint a third partner, a third person to be a partner, but still the 90% of B has to be compensated because this is an asset. So it depends what the agreement says. If the agreement doesn't say anything, then family law will apply, the Partnership Act will apply. What else? A partnership may end if a partner intends to dissolve it, to end it. So a partner sends a notice to the other and says, hey, let's end the partnership. Or you could create a partnership with a fixed term, like the partnership to sell muffins at Stanley Park. So you can come into an agreement that the partnership will end Sunday after 10 p.m. when sales are done. Right? You could do this 6 months, 1 year, several years. What else? Well, some advantages. Some advantages is you can reduce the risks with insurance. Again, reduce, not eliminate. Unanimous consent, as I said, for major changes. It's less expensive to form. Yes, just a registration. You just fill out a form and you register it. So it's $100 you spent. And there may be some tax advantages, but I won't discuss about tax advantages. Well, tax is a complex matter on itself. so I won't discuss about tax. So these are some advantages. And again, everything I discussed with you is related to a general partnership. Okay, because now we look at the limited partnership, or I prefer to say limited partner. So there's a type of partnership or a type of partner that can limit their liability. There may be an advantage here. So you may be able to invest to be in a partnership, but your personal assets may be protected. This is known as limited partner. So the limited partner, there are two requirements. One, you cannot take part in the business, in control of the business, in the management of the business. Well, if you don't take part in the management of the business, what are you? Just an owner or an investor. Just put money. Second requirement, you need to be registered. You have to be registered as a limited partner. And see, if you are registered, but you fail to follow this, and then you decide to take part in management, you lose your status of limited partner. Now, let's come back to this example. A would be better off being a limited partner, because all they could lose would be their investment. Right? That's a limited partner. A limited partner is only allowed if the other partner, at least one other, is a general one. So that's why we see the general partnership first. A partnership needs to have at least one general partner so that others can be, if they want, limited partners. Okay, so the limited partner is not simply, but is usually known as an investor. Okay. There's another type of partnership that is known limited liability partnerships, LLP. In these partnerships, each partner is unlimited liable only for their own losses, only the losses they cause, not for the losses that the other partners cause. Most professional partnerships, if you want to Google KPMG Canada, most law firms, they are LLP. So there are dozens, sometimes hundreds of professionals. They are in a partnership together, but they are personally liable only for their own losses, only for the losses they cause, and for the losses their own employees cause. They are also liable and limited liable for the partnerships debts, administrative debts. Let's say rent, let's say the secretary's wrongful conduct, but not for the other partners' wrongdoing. So if I'm in a law firm with other 20 partners, other 20 lawyers, would better be in an LLP because I have some protection. I'm not liable for my partner's wrong conduct. Okay. Here in BC, the LLP can be used for any type of business. Some provinces, they are used mainly for professionals. As I said, accountants, lawyers, could be doctors, could be dentists, professionals in general. And LLP, this acronym, needs to be in the name. How do I know KPMG Canada is an LLP? Because I Googled once. KPMG Canada, and it shows KPMG Canada LLP. This LLP acronym has to be in the name, so that third parties know they are a limited liability partnership. And LLP is different from the limited partner. This is different. This is mainly for investors. Here, mainly for professionals, not only, but mainly for professionals. Are we good with partnerships? So one last thing is joint venture. Joint venture is not a business organization. Joint venture is a name, just a name, an expression for a project. So two companies or more, they get together for a specific project. So let's say the fast train from Vancouver to Portland. Two or more companies would get together for this project. Instead of having this project in their current business units, they would form a specific business unit for this project. And they would form what they call a joint venture, but a joint venture is a contract. So companies, they enter into a contract, they set out what their obligations are, what their rights are, what resources they will have to employ, and then they go through the project. Not only with a contract, could also be that those two or more companies, they form a new entity just for that product. So it could be that, let's say, Apple and Google, they would form a joint venture for a driverless car. Why do they not have this project within their current companies? Well, because they want to limit exposure. They want to limit resources. So they enter into an agreement, or they form a new company, they form a new partnership specifically for that project. And this is called joint venture. Does it make sense? That's what a joint venture is. All right, so here you have a summary, and now you have a question. Which one is right? D. You agree? D. Still reading? D. The act sets out provisions that will govern the relationships, unless partners have an agreement that says otherwise. Does it sound correct or not? It's not about sounding. That's what I told you. The agreement is the law between the partners. And when the agreement is silent, then the partnership acts will fill in the gaps. Right? This is what this statement is saying, but on reverse. It is saying that, yes, the act sets out the provisions unless partners agreed otherwise. Remember, sharing profits or losses. The act says that profits and losses will be shared equally. If parties want to have different interests, they need an agreement. So if there's an agreement that says otherwise, then the agreement applies. That's true. D. A. Partnership Act overrides any provisions contrary in the agreement. No, that's D. That's the very opposite that is right. Canadian Partnership Act, did talk about Canadian Partnership Act or the Provincial Partnership Act, the BC Partnership Act? It's the BC. It's the BC. And then C, a partnership is only created by specific agreement. Why is this wrong? Should be. But can you create a partnership without an agreement? How do we call this, if you remember the word? Or what was the example here? Yeah, but what was my example here? Selling the muffins. So when you create a partnership by inadvertence, or when you create it inadvertently. That's why this one is wrong. Are we good? All right, so that's law of agency, partnership, sole proprietorship, and partnership.